Hello, welcome to our lecture series for Company Law Unit Module brought to you by the Simplified LLB Law Lecture Series. My name is Ayub Okayo, and today I'll be teaching you our Lecture 4 of Company Law Unit, which will cover two topics. The first part will look at a topic called the execution of company's document, and the second part will discuss the company's membership. Please join me as we learn together these two topics. Now, it's important for us to understand that after our previous lecture, formation of the company, once a company has been put in place, those who have been proposed to act on behalf of the company will start acting right away. The company does not have its own mind, so the natural persons who have been authorized by the company's articles of association to act on its behalf will then be um, required to execute the company's documents. So, for a company to execute validly their documents, there must be those who will be acting on behalf of that particular company. And there are only two um, people who have been recognized under Section 3 of the Companies Act as the authorized signatories of a particular company. And that includes the director of the company and also the secretary of that particular company. So any document which means, which is um, being purported to be from that particular company, it must have been executed by either the secretary or the directors of that company. And of course, there is a requirement that the authorization must be done by two authorized signatories. So we can have a secretary and a director authorizing a particular act, or at some point we can have only one director and a witness who must also attest to whatever the director is signing. Now, under the Business Laws Amendment Act of 2020, there has been an amendment of Section 7 of the Companies Act, which required the sealing of the company's document. And such requirement has now been modified, and companies incorporated in Kenya are no longer required to seal their documents. However, in the event that the articles of association with that particular company provide for sealing of the company's document, then they must be sealed. Now, let us now go to to another chapter, which is on the company's membership, and that is part 2 of this particular lecture. With regards to the membership, it's covered under Part 7 of the Companies Act, which provide for how one can acquire membership within a company. So there are several ways under which one can acquire membership of a company, and these methods include the following four major ways. The first one is by subscribing to the Memorandum of Association, as we already covered in our previous lecture, that at the beginning of a company, there will be a Memorandum of Association, and that Memorandum of Association must be affirmed by those who are initial subscribers of that particular company. And as such, by appending their signatures through subscription of their membership through the memorandum of association of that company, then they become members of a company through subscribing to the memorandum. And that is under Section 92 of the Companies Act. One can also become a member of a company through the transfer of shares. So if you buy shares from an existing member, you also acquire the membership of that company. One can also acquire membership through allotment of shares, and this is where the company allots shares or they put shares on sale, and at a certain point when they want to raise capital through the share subscription. So they can allot the shares as part of their share capital, and those who purchase those shares and they did not initially have the share holding or in that company, then they become part of that company as members of that company upon buying of those shares after they have been allotted by the company. Then we have another way one can acquire membership in the company, and that's through the transmission. And this particular one, it can be after an occurrence of an event that requires that those shares should be transferred to another person. And that can be in the event of death or bankruptcy of a member of a company. So if maybe, let's say, I have maybe shares within a company, and in case of death, then that those shares that I own within that company will go to my next of kin. And in case of bankruptcy, the shares owned by one will now go to the receivers or the creditors of that person who has been adjudged as bankrupt. And other than these four major ways of acquiring company membership, we also have other ways under which one can be deemed to be a member of that company. And one of these will be acquiring of shares through share qualification by directors. So sometimes there can be a requirement that directors subscribe to the shareholding of that company. And in that kind of event, then the directors also become members of the company, despite the fact that they will be acting in a capacity of directors first. So there are instances, if we teach this in corporate governance, where directors may also be required to have a share capital within a particular company. And as such, they may be remunerated by way of calculating their pay using the share price. And many of organizations and companies, they opt to give directors a part of their shareholding for them when they are running their business. And of course, the moment they get acquisition of those kind of shares, they qualify to become as one of the members. And of course, if may also add this, that sometimes employees can also have such shareholding, and despite being the workers, or rather the employees of that company, they can also be owners of the company, or rather the members of the company, through subscription of the shares. Now, the shareholding or membership of the company does not exist forever. At some point, one may cease to become a member of that company. And as we shall see in another slide, there is a requirement that a company keeps the record of their membership. So that record of membership can keep changing, and any alteration of cessation of being a member or acquisition of shares and becoming a new member in a company, such kind of record must be kept at the head office of that particular company. Um, so a person may cease to be a member of a particular company in several ways. One of which can be through a transfer of shares, where you transfer your shares to somebody else through a sale on maybe a stock exchange market, or even individually when shares are floated. And this, of course, happens in both public and private companies. How the shares are transferred within the public company will be, shares are not, shares in public companies, that are freely transferable, as opposed to the shares within the private company that may require consent of the other members before you can transfer your shares. But once you transfer your shares, then you cease to become a member of that company. Death is also one of the ways in which one ceases to be a member. If you die, your name is removed from the list of members of a company. Bankruptcy still works the same way, and or then forfeiture of the shares. Now, with the forfeiture of shares, sometimes it can be that a company requests or um, uh, wishes to do away with certain class of shares, and they may request members who have certain shares um, to forfeit their shares. And in such instances, some members may cease to continue being members after that forfeiture of the shares they own in that company. Then we have the repudiation by an infant in the event that the shares were in the name of an infant. When an infant becomes of an age of majority, they can uh, uh, they can void the contract or void any dealings to cease being members of a particular company. So they are given that chance when they become of age to make that decision on whether they want to be to continue to be members of that company or they wish to cease membership. So we may also have redemption of shares, and with this kind of share cessation of share capital, it happens in a way that we may have redeemable shares. And we'll talk about this when you're talking about the shares. So we have redeemable preference shares. And as such, if those shares can be redeemed back by the company itself, maybe through a share buyback or something like that. So if shares have been redeemed by the company and those who held those redeemable shares, they may cease to become members if all the shares they held have been redeemed. The cessation of membership will also come when a company is going through a winding up or liquidation. So if a company is insolvent and it's winding up its business operations, then all those who had subscribed towards their towards the capital of that particular company, we will cease to be members at the time when the company is being wound up. Now, companies are required to keep and maintain a register of their members. I had mentioned this earlier that a company is required by law to make sure that they keep the register of who is their member. And in that register, there must be a date when one became a member, um, or the number of shares and the number of shares they hold after they've subscribed to become members of that company. It will also have the details, the personal details of that member, including the name and the personal address, and also the next of kin and things like that, which have been put in the register of the members of a particular company. Now, when we're looking at the members of the company, we must have an understanding of the beneficial ownership of our company. So, who can be deemed to be a beneficial owner of the company? Section 3 of the Companies Act defines a person who can be deemed to be the beneficial owners of the company to include a natural person who owns or controls a part of that company's stake or has an arrangement um, with a company in a way that they will do or they do transaction on behalf, or I mean, not rather on the behalf, but they will do a transaction to benefit from that juridical person. So if they have any control to benefit from this juridical person, in short, a beneficial owner is somebody who will get the gains of a particular business. And that's a company. Once the company has been formed, the gains from that company. Remember, the company is being constituted or being brought to existence for the purpose of making business or to make profits for those who have subscribed towards their capital. Now, those who have subscribed towards the capital of that particular business, they will be the beneficial owners and they will receive returns from the profits of that particular business. And of course, that will cover it extensively when we're looking at how dividends of a particular company are calculated and how they're distributed among the beneficial owners. Under Section 93A of Companies Act of Kenya 2015, there is a requirement that a register of beneficial owners be maintained. And as such, if it needs to be updated, as I said, if one member has ceased to become a member, and the the company must update the record on who has now taken over the shares of as the new member. And those who have ceased to be a member, their details in the record should be deleted within the register of beneficial owners. Under the company's beneficial owners information regulations of 2020, it provided for conditions that must be met by one to be deemed as a beneficial owner. And it puts several scenarios. One of them is that one must have at least 10% of the issued share capital of that company. It also provides that in the event that somebody has at least 10% of the voting rights within a company, then can be deemed as a beneficial owner, and their name should be kept within the register of beneficial owners as required under Section 93A. Also, the beneficial owner under this beneficial ownership information regulation, it provides that one who has powers to appoint or remove directors from the company. Any person who has the right to vote and maybe remove or appoint a director can be deemed to be one of the beneficial owners. And of course, any person with an influence or either directly or indirectly to control or exert control on a particular company may also fall under the same category of ownership. And it's worthy mentioning here that when we're looking at the owners of this company or the members of this company, we will, of course, discuss this when we're looking at the directors of a company on how the owners of the company, or rather the members of the company, they hold directors accountable for actions that they do, especially any actions that will go in contravention with the articles of association of that company. So the members of the company have several rights, like rights to vote in a general meeting or any other meeting called by the company for the members. They also have the right to enjoy the dividends of a company when the company is making profits. And of course, they also have their own liabilities and rights as are provided for under the company law. So the control and influence of these beneficial owners of a company may extend this control to the directors or how the company is being run. When the shareholders are not happy, they have two choices to make. If they're not happy with the running of the company, they have two choices to make. The first choice is to sell their shares to another person and exit the company. And the second option is to make a vote on removing directors or correcting a wrong which has been done on that particular company when they are not happy that the company is being run in a manner that is in within the confines of the law. So they can do either voicing out by way of vote or exiting the company by way of selling their shares. Now, Membership right of these members who subscribe towards the capital of this business or this company, they must comply with the membership governance, and the membership rights of those members is governed by the rule of majority. So we have what we call the majority rule. And the majority rule, let me first maybe break it down in a bit, that we have a group of members who have called beneficial ownership, beneficial owners of that company. These members of that company, they act in a way of voting based on their stake, their shareholding stake within the company. So if one has only one vote per share, I mean, one person, one vote, then that's the amount of influence they will have within the company in case of a meeting which has been maybe called for all members. So members will have to make their vote. The majority vote within that meeting will carry the day. So the membership right is governed by the majority rule, where the majority membership vote in a general meeting or in any meeting which has been called by the directors of that particular company, maybe to come up with any resolution, they must go by the majority rule decision. This was established in the case called Force versus Haboto. I will encourage you to read this case called Force versus Haboto because it is the locus classicus when we look at the matter on the voting rights, especially on the majority rule. In this case, established three major principles. The first principle is that if there is a wrong which has been done to on the company, then the proper plaintiff to go to court is the company itself. So whatever has been voted in the meeting, it will stand. So if there is a problem with that, then the proper plaintiff to go to court on behalf of its own self is the company, not a person, one of the minority shareholders who is complaining of a decision which was made by the majority who decided in a general meeting. The second principle that was also established in Force versus Haboto is that internal management of the company should be left for the company itself internally to deal with it without any interference by the court. Now, with the internal management principle, it calls for like let the articles of association make the dictations on what should be done and what should not be done, and let the managers do this management within with the um, let the managers do this management within the confines of the law. And in case of anything, of course, the company can take the directors to court in case of any violations in its own name. And of course, that will be difficult if the directors are the one to act on behalf of the company by taking the company to court. Unless otherwise, it will be very difficult for directors who are in breach to take their wrongdoing to court. But of course, sometimes one director might have done wrong, but other directors within the board vote to take the matter to court. There's also another principle of irregular principle that was found in the Force versus Haboto case. And under this principle, it's like these small irregularities that can be corrected internally by the members themselves in a general meeting should not make a court to be attracted to meddle in the normal irregular business of a particular company. So the court will be hesitant in coming to aid the minority in case of there is a problem on a decision which was made by the majority in a general meeting. There is, however, an exception to the rule in Force versus Haboto, and this exception is that there are times when the majority rule does not stand. At times, there are instances where we can say, okay, we agree, the majority have decided this, but other than that decision, it is in contravention with the law, and as such, it should not be left to slide just like that. So the principle in Force versus Haboto, it has several exceptions, which include ultra vires or illegal acts. Now, we will talk about ultra-vires act in our second last chapter, when we'll be looking at ultra-vires act of a company. Ultra-vires act of a company comes through the memorandum of association. Remember, we talked in our previous lecture when we're looking at the memorandum of association that it sets out the objectives of a particular company and how the company can be done. In case those objectives have been or amended, or they have been disregarded without notifying the registrar of companies, then any act which is being done in the name of the company will be deemed to be ultra-vires acts, and they will be illegal and sanctioned on the company. There are also some ultra-vires acts that can happen, especially by the directors of the company when they violate the rules which have been stipulated within the Articles of Association. So, such illegal or ultra-vires actions of a company, or ultra-vires decision by the majority, even if the majority have made that decision in by way of votes, and that decision is ultra-vires, then a minority can complain in court. There can also be a special or qualified majority decision. We may have, maybe we may have an element where a specific decision can only be done by a way of special or qualified majority. And there may be a special majority where we say maybe two-thirds, or maybe they may say 75% of total votes to be for a particular action to be authorized by the members. And if so, in the event that the vote happened but they have not attained the qualified or special majority, then such decisions may also be challenged. In the event that an individual right of a member has been infringed, then that particular member can also go to court on their own behalf to complain on the wrong done to them. And that would be also an exception to the rule in Force versus Haboton. Um, in another event where there is a fraud which is being perpetrated on a minority, that can also attract that particular minority to approach the court and disregard the majority rule decision. And then, of course, oppression of the minority. If this decision is being done only to oppress a simple majority, or a particular minority rather, then a court may interfere or intervene in such kind of um, scenarios. Now, as we've heard that the majority rule prevails in um, a membership meeting, it's also important for us to know that the law does not disregard or neglect totally the minority protection or the minority rule. So there are several protections that have been coded within our Companies Act in a way that it supports or protects the minority of a particular company. And of course, as I already said, that there are instances where if minority are being oppressed by the majority rule, then the court may interfere. So the general rule in Force versus Haboto, which is on the majority rule prevails, may in some instances be interfered by the court, especially if such kind of decision by the majority has been arrived at in contravention with the law, or is being arrived at in bad faith, or only to benefit the majorities. Then the court may intervene um, in such kind of scenarios. And of course, at common law, there were two major ways under which the court may intervene in a way of protecting the minority. And that was where the majority are making their decision in bad faith, or they are contravening the law or the articles of the company when they are making such a decision. Under the Company Law Act, we have several safeguards for the minority, which protects the minority from the majority rule. And such protections of those minority rights come in several folds. One of which it's on the variation of class rights. You cannot vary the class rights over a particular shareholder. So where they want to vary maybe from a specific class of shares to another, we will discuss this in when we're talking about the shares, where we discuss about different types of class of shares. And in case they want to vary that class of shares, then they must they must do it within the confines of the Articles of Association. Where there is a need for a meeting, minority members can also request for the company to hold a general meeting. So that's also another safeguard within the Companies Act for the minorities. Whenever there's a takeover bid, the minorities must have their vote and they must be given a chance to participate within the confines of the Articles of Association. And of course, there are actions which we call unfair prejudice actions that can be brought by the minority shareholders in the event that a company is in violation of several principles or parts of the Articles of Association of a particular company that may warrant a call for unfair prejudice action against maybe a specific actor within the company. Now, what is the unfair prejudice action as put in Companies Act? So the unfair prejudice application can be made by a minority member on the grounds that the company's affairs are being conducted in a manner that is oppressive or is unfair to the interests of the other members. Either generally, or the all members will be affected, or a part of members will be affected. Also, these particular unfair prejudice actions should be whether it is actual or is anticipated act or omission by maybe a director. It must show that such action or the act which is being complained to be done or not to be done, it will be oppressive or prejudicial to a section of membership. So if it will be prejudicial to a section of members, either or generally on all members or a part of membership, then a such member can bring unfair prejudice action against such actors. Now, when the court is looking at these unfair prejudice actions, it must make sure that once it assesses these claims and finds that there has been violations, a court may issue several orders or assist in several ways. One of which may regulate the conduct of how that particular company will act in future. May say they have put an injunction the company should never do a certain act. If, let's say, for example, there's a requirement of sealing of a company document, and in several actions, the company has done communication without sealing the document. In such event, the court may give an order that from that time henceforth, the company must seal their documents. That can be order from the court. Of course, the court can also order that an act which is being complained on be refrained or be undone by that particular company. So, if directors um, may be maybe ordered to maybe call for a meeting, or maybe to some extent they may be ordered not to do a certain act for an act which may be prejudicial to a member. Also, a court may authorize for a civil proceedings to be brought in the name of a derivative claims, and we'll deal with this in another slide. Now, the derivative claims may be brought on behalf of the company in the name of that person who is complaining. It's not the name of the company itself, but is in the name of the uh, uh, a shareholder who is complaining of an unlawful act or unfair prejudice action that has been occasioned on the company. And these derivative claims are being brought by one person in their own name on behalf of the company. And of course, the court can authorize such kind of proceedings to be brought as one of the remedies that a person who brings unfair prejudice action can get from the court. The court may also require that an articles of association be altered or be modified. Remember, we discussed this in our previous lecture, that articles of association may be varied, or the court may also limit variation of those articles of association, especially if it will be in contravention with the Companies Act. So the court may order that the articles be altered or cease to be altered unless there is a leave of court. There are also instances where the court may order that the shares of a particular member be purchased, and that can be in the event that maybe a member wants to cease becoming a member and is being frustrated. He wants to sell their shares um, and then want to leave. A court may give an order that their shares either be redeemed by the company or be sold on the market. Now, what about the derivative actions? The derivative actions I had mentioned a bit, which is in part 11 of our Companies Act. And these derivative actions are those actions that have been brought by one shareholder in their own name on behalf of the company for a particular wrong which is being complained of. So there can be a wrong which this shareholder deems that it's um, it's a wrong against a company, and he wants to remedy that wrong, and he cannot bring. Remember, we already said in Force versus Haboto that the proper claimant is the company itself. But in that regard, they maybe those who are supposed to represent the company, maybe let's say the directors to take action, they are the ones on the wrong. So this shareholder is suing the directors on behalf of the company for a wrong which has been done on the company. So he just wants that company, that the wrong done to the company to be remedied, and nothing on their personal interests or their personal rights. So they may also bring that derivative claim against a person on behalf of the company in their own name. Remember, that's very important that the claim must be in their own name's behalf. Now, The act which is being complained can be, of course, an act or an omission by the director or those in seniority within the company, mostly the directors who may be at wrong, or the board generally that may be, which may have maybe acted or omitted to act, and of which such action will be either an act of negligence or will be default or in breach of their duty, or the breach of their due care, or the breach of trust, whichever way it will be a violation. Such derivative claim must bring out that fault which has been done to the company. So they must bring out which the act which they are complaining on behalf of the company. So derivative claims can only be instituted within the confines of the Companies Act. So the Companies Act provides many scenarios in which a derivative claim may be brought on behalf of the company against any wrongdoer, especially those who are in total control or in factual control of that particular business. Uh, so the Companies Act provides for several conditions that must be fulfilled for derivative action to come, one of which must be the fraud conduct which is being complained of is being done by the majority through their majority rule, and it's being done on the minority. So the minority will, or one person will bring the claim to court because the majority are in control. And of course, the second condition is the control, that those who are the wrongdoers, those who are violating the maybe the articles of the company or any duty bestowed on them, must be legal or factual control. So there must be either legal or a factual control against the minorities. So it can be like the and maybe an act is done by the majority. Maybe an act was maybe done or by maybe the board or a particular director, or a vote was taken in a general meeting to alter maybe the articles or to alter any part of maybe the memorandum, and that vote was taken by the majority. So factually, they are in control based on the number of their voting rights. Or perhaps if it's directors, they are in legal control of that particular company, and then nothing will be done unless a claim is being taken to court to compel them to do a certain action. We also say that the proper plaintiff to go to court is the company itself. However, in derivative action, a plaintiff can go on behalf of the company, and that particular plaintiff can be a shareholder. They are going on behalf of the company. They are only representatives of the company, and they are not launching this claim on their own for their own benefit. So it's not for the shareholder to benefit, but on behalf of the company, and not on behalf of of themselves, but on behalf of the company and other shareholders. There can be a section or a part of minority shareholders who are complaining of an action which has been done on the company. Finally, it's also important that we note a condition um, on the parties to appear in that particular lawsuit. So the Companies Act provides that the company which is the company where this derivative action is being sued on their behalf must be named as a nominal defendant in that particular suit. So they should also be included as one of the parties in that particular suit as a nominal defendant in such kind of a suit. So that is it for this particular lecture. That's lecture 4 of our company law lecture series. The next lecture will cover lecture 5 on the directors of that particular company. Until then, thank you very much and see you in our next lecture recording.